Evictions can be deceiving. On the one hand, Arlington Justice of the Peace Courts do a great job of helping you start the eviction process. They really do make the process seem easy. And in a very limited set of circumstances, the process is easy. But the documents the Arlington courts provide often lead landlords into making several mistakes. For example, you want to set up your eviction petition so that you can evict your tenant for multiple reasons. You don't want to find yourself looking back at the judge with that blank expression on your face after your tenant proves he resolved the one reason you cited for evicting him. Also, your affidavit of non-military service needs to be supported with a special certificate obtained from a Department of Defense website. Not including this certificate along with your affidavit will nearly always mean you committed perjury. You don't want to commit a crime in the presence of a judge. And these issues are only two of the problems you're likely to run into while starting your eviction. There are many others. More importantly, the eviction process gets more complicated the further along you go. The trial can become quite complicated if your tenant chooses to appear. You'll need to be prepared in the event your tenant attempts to lie to the judge, and unfortunately, tenants lie to judges all the time. You also need to be prepared should your tenant want to settle. Settlement agreements need to be in writing, and they need to be enforceable. You really need to know what you're doing if you want to ensure your settlement agreements are enforceable. It's very easy to end up with a settlement agreement that requires you to restart the entire eviction process after your tenant violates the terms of your settlement. And Texas law won't permit you and your tenant to waive the eviction process by agreement. There's a very specific way settlement agreements need to be worded. If your tenant appeals, you'll be at a huge disadvantage if you don't understand the three different appeal methods. You'll also need an understanding of when you want to challenge an appeal versus when you don't want to challenge an appeal. You need to understand how to fast-track an eviction appeal. Tenants routinely file appeals, but fail to do something called perfecting the appeal. This situation is a very common one in appeals. More importantly, it's a huge opportunity for landlords, and it seems like most self-represented landlords miss out on this opportunity. My law firm focuses exclusively on the needs of Texas independent real owners. We've successfully represented hundreds of landlords in eviction cases, and we offer eviction representation at all levels: Justice of the Peace, County Court at Law, and Texas Courts of Appeals. Give us a call today at 817-659-2079. I want to schedule a free, no-obligation consultation with you. If you're thinking about starting any part of the eviction process on your own, please don't. We find many landlords start the eviction process believing they're going to save themselves some money. In fact, they often end up costing themselves more. That number again, 817-659-2079.